A very warm good morning to all of you. Dear students, once again I would like to welcome all of you to a new session of the Civics class. Today we are continuing with the same chapter from Civics, chapter number 4, the Supreme Court, part 3. I hope you have learned the previous part very well. Do you remember what we were discussing in the previous class? In the previous class, mainly we were focusing on two different points. First one, we were discussing about the qualifications for appointment as a judge of Supreme Court. And secondly, we were discussing about the appointment of different judges in the Supreme Court. So these were the two main points which we were discussing in the last class. And today we are going to discuss a few new topics from the same chapter. First one, composition of Supreme Court. And secondly, we will be discussing about the different writs or important writs which we will be issuing from the Supreme Court. So these are the two different points which we are going to discuss today. First of all, we are going to discuss about the composition of Supreme Court. The Supreme Court of India consists of a Chief Justice of India. So first of all, there will be a head in our Supreme Court, or in other words, there will be a leader who will be looking after all the activities of the Supreme Court as well as different high courts and other subordinate courts. So the most powerful or the most important person in the Supreme Court is the Chief Justice. So at the top of the Supreme Court, or at the head of the Supreme Court, is the Chief Justice of India. So there will be a Chief Justice and not more than 33 other judges. Okay, so 33 judges plus Chief Justice of India. So altogether 34 judges will be there in the Supreme Court. And as I have told, not more than 33 judges, which means a fixed number is given to the Supreme Court, or in the case of the number of judges, a fixed number is there, that is 33. It cannot exceed more than 33, and it is possible. It doesn't mean that it cannot be increased. It is possible if Parliament prescribes. If the Parliament feels that 33 judges are not enough to deal with the different cases which coming to the Supreme Court, then they can issue the ordinance or the order by which the number of the judges in Supreme Court can increase. The best example is there was an Amendment Act, the Supreme Court Amendment Act 2019. Okay, in the last year there was an order, there was an Amendment Act which received the assent of the President. So the Parliament has passed the bill or the order, and it has gone to the President, and President has assented, or President has agreed with that. As per the order of the President, the number of judges increased to 33, which means till 2019 the number of other judges in the Supreme Court was just 30. And in 2019, as per the concern or the prescription of the Parliament, the President has agreed with the decision of the Parliament, and in 2019 3 more judges added to the number of judges of Supreme Court. So in 2019, from 30 the number has got increased to 33. That's why I have told you, right now in Supreme Court 33 judges plus 1 Chief Justice is there. Altogether 34 judges are there in the Supreme Court. So this is what is the composition of the Supreme Court. 33 judges plus Chief Justice, altogether 34 judges are there in the Supreme Court. Now we are going to discuss about the important writs. You might have heard this particular title before when you were dealing with the fundamental rights of our people or the citizens of India. So we are going to discuss about the different writs and what is the purpose of writs. If there is a violation of the fundamental rights of the citizens, they can move to the court, and Supreme Court as well as High Court can issue writs to enforcement of the rights. When we were discussing about the fundamental rights in class 9th, you might have studied a particular clause or a particular fundamental rights, right to constitutional remedies, which means if any of the five fundamentals are being violated by some authority or by other people, we can move to the court and the court will ensure that we will be getting our fundamental rights. So the same thing is happening here. In order to implement or in order to provide fundamental rights of the citizens, the court has got some means to enforce the fundamental rights, and in order to enforcement of the fundamental rights, court is using a few number of methods, and those methods are being known as writs. That's what I have explained here. If there is a violation of the fundamental rights of the citizens, they can move to the court and the court will issue certain orders, and those orders are being known as writs. Now let's see what are the different writs. Altogether 5 different writs are there. Let's see what is the first writ. The first writ is being known as habeas corpus. Habeas corpus, which means to have the body. The meaning of the word habeas corpus means to have the body. Now there will be a question from your side. You will be having a doubt how it works. This is how it works. The High Court or the Supreme Court can get the body of any person released. So when the Supreme Court or the High Court can ask a person or an agency or a group or the authority to present the body, if unlawfully detained by person or a group or by state. Suppose, just imagine, police arrested a person, and according to the rules of our nation, the arrested person must be presented in the court or before the court within 24 hours. So that's what is the rule says. But if the police is not presenting or submitting the person in the court even after 24 hours, we can move to the court with the we can move to the court for getting our fundamental rights. We can file a habeas corpus, and the court will order habeas corpus, and as per the order of the court, the police has to present. They don't have any other choice. They have to present the person in front of the court. So the High Court or the Supreme Court can get the body of any person released if unlawfully detained by a person or a group or by state. That's why we can say that it is a great safeguard for the personal freedom of a citizen. So suppose if a person kidnapped us, okay, so our relative can move to the court and the court will order habeas corpus. So it is a great safeguard for the personal freedom of a citizen. So the first writ issued by the Supreme Court or the High Court is habeas corpus, which means to have the body. Okay. Now let's move to the second writ, that is mandamus. It is being pronounced as mandamus, which means we order. Mandamus means we order. A command or an order from a superior court to a lower or an administrative authority. So a High Court or Supreme Court is ordering to its subordinate court or to an administrative authority or any of the department of the government. They are ordering. A command is given to that particular administrative authority or to a subordinate court or a subordinate or lower court. So this particular writ is being known as mandamus. And what is the purpose of this particular writ, mandamus? It is to perform certain duty. So a superior court is asking to a lower court or an administrative authority to perform certain duty. So if they fail in their duty, it's a responsibility, or it is the order given from a superior court to a lower court or an administrative authority. That's why it has got the meaning we order. Mandamus means we order. So I hope that you have got a very clear picture about the second writ, that is mandamus, we order. Let's move to the third writ, that is writ of prohibition. Writ of prohibition. It is an order of a superior court to a lower court. So there will be a confusion regarding the previous writ and the writ of prohibition. What was the previous one? Mandamus, and right now we are dealing with writ of prohibition. In the case of mandamus also we have seen an order from a superior court to a lower court. So what is the difference between both? Yeah, there is a difference between both of these writs. Let's see what is that. Writ of prohibition says about to stop certain proceedings. And what we have studied about mandamus, mandamus means issuing an order to perform certain duty. But in the case of writ of prohibition, they are ordering to stop certain proceedings. So I hope you have got an idea about the difference between mandamus and writ of prohibition. So writ of prohibition is asking a lower court to stop its proceedings. Why? Because they might have violated or exceeded the jurisdiction of the lower court, which means every court or every different kind of courts are having their own jurisdiction. There are certain areas in which they can interfere or in which they can issue their verdict. So once if they violate or once they exceed the jurisdiction, a superior court can issue the writ of prohibition, which means they can ask the lower court to stop its proceedings. So that's the third kind of writ. What is that? Writ of prohibition. Ask a lower court to stop its proceedings. So we have deal with three different writs. First one, habeas corpus. Second one, mandamus. And third one, writ of prohibition. Now we are moving to the fourth writ, that is writ of certiorari. How it is being pronounced? Writ of certiorari. And what is meant by writ of certiorari? It is issued by a superior court to a judicial authority. So there is a very clear definition given here. This particular writ is being issued by a superior court to a judicial authority. It is about the desiring to be informed of what is going on. So what is the order or what is the particular notice given by a superior court to a judicial authority? So they are asking, or the superior court is asking to the judicial authority to be informed of what is going on. So the judicial authority to inform, or it's their responsibility to inform what is going on to the superior court. So you might be having again a doubt regarding similarity with the writ of prohibition. The writ of certiorari is having some similarity with the writ of prohibition. But I will give you the explanation. What is the difference between writ of prohibition and writ of certiorari? Writ of prohibition is issued when certain proceedings are going on. As we have seen, writ of prohibition means it's an order given to the lower court to stop its proceedings. So when certain proceedings are going on, writ of prohibition is being issued. But the writ of certiorari is used after the order has already been passed by the lower court. So once if the lower court has completed their proceedings, the superior court or the higher courts will be asking, or the lower court has to inform what is going on. So that's what is the difference between the writ of prohibition and the writ of certiorari. So I hope you have got a very clear picture about the difference in the case of writ of prohibition and writ of certiorari. Now we are moving to the last and final writ, and that is quo warranto. So how it is being pronounced? Quo warranto, which means by what order. It is a writ which is being issued when a person has usurped any office. What is meant by usurped? Usurped means seize someone's power. So this particular writ is being issued when a person has usurped anybody's or anyone's office. It thus prevents public officers from forcibly or wrongly holding a high public office. Suppose, just imagine a district collector who got transferred or who got transfer letter from the government, but he is not ready to vacate his seat or his position. And in such cases, the High Court or the Supreme Court can issue quo warranto in order to ensure that the person who got transfer will be vacating his position as early as possible. Okay, so nobody is permitted to seize someone's authority at any circumstances. So these are the 5 different writs which is upholding or safeguarding, protecting the fundamental rights of the citizens of our country. So the high courts, the different high courts as well as the Supreme Court is making sure that our fundamental rights are being protected, or each and every citizens of the country is getting their fundamental rights, in order to make sure that such a facility is provided by our constitution. So dear students, I hope that you have got a very clear idea about today's class. Do you remember what we were discussing? First of all, we were discussing about composition of the Supreme Court, and then we were discussing about the different or 5 different writs issued by the Supreme Court as well as the High Courts. So with this, we are winding up today's class, and we will be continuing our topic in the next class. Till then, I would like to sign off. Thank you.